I'm Walter Isaacson. I'm here with Professor Joseph Ellis. We've been talking about the founding of our country, and now we're talking about the Bill of Rights. We've done the first three amendments. The one that's amendment number 4 is particularly interesting because it shows how something written 200 and some odd years ago is quite relevant to today in different ways. It says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And then talks about warrant, how you have to have warrants. We're still dealing with that a bit when it comes to eavesdropping, wiretapping, and for that matter, cybersecurity.
Well, I remember there was a big, constitutional debate in the 60s whether the Fourth Amendment was essentially a recognition of the right to privacy. But I think the judgment is threatening privacy is a level of intrusion that was probably unimaginable to anybody in the late 18th century.
So you don't think Madison, when he wrote this, thought much about the NSA eavesdropping?
I don't think so, although I think he thought about analogous intrusions into his own life and in his own time by often British agents. Remember when he would write to Jefferson from America to France, he wrote in code because of the snoopers.
So what was Madison thinking when he pushes for unreasonable search and seizure?
I don't think he was thinking about a hacker in an internet situation. I think he was thinking about troops coming in and ruffling through your papers and
But they basically couldn't search your home unless they had a warrant.
Yeah.
And that was something that was not fully established before the American Bill of Rights.
That's right. I mean, that's not in, well, there is no written British Constitution, but it's actually also interesting that in the United States, for the first time, with the passage, believe it or not, of the Alien and Sedition Acts in 1798, for the first time, truth is a defense against libel.
But what's particularly interesting to me about this amendment is that it does grow with the times. And even the very words that you need warrants, that you have to describe what's going to be searched, that's now what we're interpreting when we say, do we have the right to eavesdrop? Do we have the right to, use NSA surveillance? It reminds me again of how it's a living document. Let's go on to the Fifth Amendment, very famous, which is that no person shall be held to answer for capital or otherwise infamous crime unless on the presentment or indictment of a grand jury. And then it goes on to say they shall not be compelled in any criminal case to be a witness against himself. What was that all about? Why were they worried about that?
A lot of state constitutions had this language in them.
Was there a Star Chamber?
They're thinking of the British version of the Star Chamber in the 17th century. Also, vice admiralty courts in the Revolutionary era are used to essentially prosecute people for violating the Navigation Acts in a way that takes away their rights. So they're thinking of the experience of the British in the colonial and the Revolutionary era, and a lot of the states recommending amendments had this in. There's a consensus here that we can fix this, and we've learned our lessons, and we can set up a judicial system that functions as to prevent those kind of injustices.
And let's finally leap ahead to the 10th Amendment, which is the one where they're balancing everything, the rights of the states versus the right of the central government. The powers not delegated to the United States, which is what they're now calling the country, by this Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. In other words, if it's not in this Constitution as the role of the central government, it's a state right.
That's absolutely clear, but there will be no agreement as to where that line is drawn. Certain people see enumerated powers in places, say Hamilton does with regard to fiscal policy. Certain people go back to Pennsylvania, like Wilson, and say, this ends slavery.
Right.
People go back to South Carolina and says, we are guaranteed in the 10th Amendment that they can't do that. So this is a living document. This is now being used by members of the Tea Party to justify their opposition to federal government programs.
And it's why, for example, we have to use clauses in the Constitution to say this is a national issue, like the Commerce Clause.
Or the Necessary and Proper Clause. I like that one better, because commerce, we made commerce everything to justify the federal role in the state. But the way the bank was initially approved in 1791 was on a brief written by Hamilton using the Necessary and Proper Clause in the Constitution to say that they were justified in so doing.
And this is, once again, part of a living document in which we say some of this is federal and national government, and some of it is a state government. And we have an amendment that says, let's keep this in balance, and you're going to have to figure it out every new generation.
And that's what we do.